First order of business the court needs to take up this morning. I have two motions to recuse, one filed by defendant Jeffrey Williams that was filed yesterday and handed to the court at the end of the business day. Another one has been filed under the same indictment, just indictment 22 SC 183572. And I want to say that motion to recuse has been filed on behalf of Miss Kayla Bumpus. Can I get the lawyers for, or the principal lawyer for that particular case to identify themselves for purpose of the record?
Hey, Judge, good morning. Gabe Banks.
Good morning, Mr. Banks.
Okay, so both Mr. Steele and Mr. Williams and Miss Bumpus is calling for him to recuse himself because she has been called to this hearing on the 25th and she don't want to go there. I understand why.
Her legal team is also here. Mr. Collins, this morning. And,
legal team.
All right, good morning, counsels. Okay, as it pertains to your motion, Mr. Banks, and on behalf of everyone that is here, I'm going to just take up the issue of the recusal. I'm going to defer the issue of the motion to quash at this point in time, okay? So I'm not going to take up anything. I can't do it anyways because the rules require me to go ahead and deal with the motion to recuse to begin with. So I've ceased any other business, and that's why I had Mr. Chamberlain reach out to you last night and counsels for you all to be here this morning so I could take this up. Your motion actually was filed last Friday at 10:40 p.m. It didn't appear in the system, however, as sometimes Odyssey happens, until sometime on Monday evening. So when I started to read Mr. Steele's affidavit last night, we were put on notice that there was possibly another affidavit out there and another motion. So that's why we had to call you, okay? So that's how we got here with this. Or did you all attempt to send me independently a copy of that, or?
we did not, Judge.
Okay, no harm, no foul, no. So no, I just wanted to know if you had attempted to do so, because we would have certainly, had we known that, pulled you in on Monday morning, which would have been the closest time that I could have heard your particular motion. So just from a time aspect, I just wanted to account for that. Taking a look at this applies to both motions that have been filed to recuse the court or disqualify the court. Recusal by a Superior Court judge is governed by Uniform Superior Court Rule 25, etc. Rule 25.1 provides that all motions to recuse and disqualify a judge presiding a particular case or proceeding shall be timely filed in writing, and all evidence thereon shall be presented by accompanying affidavits, which will fully assert the facts upon which the motion is founded. Filing and presentation to the judge shall not be later than 5 days after the affiant first learned of the alleged grounds for the disqualification, and not later than 10 days prior to a hearing or trial, which is the subject of the recusal or disqualification, unless good cause be shown for the failure to meet such time requirements. And that is cited in Georgia Uniform Superior Court Rule 25.1. So I'm applying that to both sets of motions to recuse. And applying this rule, Georgia courts have held that when a motion to recuse is filed, the trial judge shall immediately, 1, determine the timeliness of the motion, 2, the legal sufficiency of the affidavit, and 3, the legal sufficiency of the grounds, and has no power to do anything else. And that is Robinson versus the state, 332 Georgia Appeals at 242-41. The 3 threshold determinations that the trial judge must make in regard to a motion to recuse are whether it's timely filed, whether the affidavit made in support is legally sufficient, and whether some or all the facts set forth in the affidavit are true, recusal would be warranted, and that is Dacker versus the state, 300 Georgia, 74-77, 2016. The judge finds any three of the conditions have been met. No, I'm sorry, take that back, strike that. If the judge finds that all three conditions have been met, he must refer the motion to another judge to hear the motion, but if any one of the conditions is not met, there is no error in denying the motion. And motions to recuse are viewed and considered by the appellate court for abuse of discretion. Accordingly, the court is going to address each one of the factors as it pertains to both Mr. Steele's motion and, for shortness, Mr. Banks' motion. I find both motions were timely filed. I find that Mr. Steele's motion was in fact filed on this past Monday,
Which is 5 days exactly.
which would have been the 17th of June. I find that Mr. Banks' motion on behalf of Ms. Bumpus was timely filed, as it was filed on the filed on the 14th of June at 10:40 p.m. Secondly, I find that in addressing the legal sufficiency of the affidavit, that means, was it sworn? Was it sworn before a notary is in proper form? I find Mr. Williams and Ms. Bumpus's motions to be, or I should say affidavits, to be in proper form. The third thing that the court has to review, and like I said, I reviewed, is the legal sufficiency of your grounds of the motion. And
Yes, Judge.
And here's where the court finds that upon a review of Mr. Steele's motion and affidavit, as well as Mr. Banks' motion and affidavit, that both contain assertions bare assertions and legal conclusions which aren't sufficient for the court to grant your motion at this point in time and refer it to another judge for it to be heard. So I'm going to deny the motion at this point in time. I invite you all to look at Baptiste versus the state. Just because adverse rulings have been made doesn't mean that the court stops the trial. So I'm going to make that. I'll reduce both of the motions to recuse to an order, and I will file that so you can take whatever steps you need to necessarily after that. But I don't get into anything about the affidavit itself, argument on that. I just have to read it. Those are the only three things I do. And then if I find it to be not sufficient on its face, I go for it. I just make the ruling at that point in time, let you all take it up. No, I won't grant a motion for a certificate for immediate review. And that's where we are at this point in time. Anything else, Mr. Banks?
If I could just briefly be heard, Judge.
Sure.
Please. And I'm not trying to, I understand the court's ruling and we'll proceed as we see fit. I do take issue with the court's characterization about the legal insufficiency of the affidavits.
Well, that's why when it was reviewed on appeal,
Sure.
it can certainly be, the appellate court will review my ruling for abuse of discretion.
Certainly
Okay.
understand that, Judge. And in stating that, Judge, I would just say that one of the issues that is raised in our affidavit, because our motion to recuse is to recuse you from the contempt proceeding, not the underlying criminal case in which Your Honor is presiding. And so we really don't have an issue or standing to even challenge that. And so to the extent that there is a contempt proceeding that is set for the 25th, Your Honor, you are a witness to that proceeding. And so because you were a witness.
I don't believe you. I'm not going to get into any argument, but I can't. So that's your assertion at this point in time. And like I said, when that is taken up, I'll consider it. I also remember, I still need to rule on the issue of.
Judge Glanville, you lying sack of shit. You're lying, and you know you're lying. You were a witness in that ex parte hearing because you agreed to the prosecution holding it. You're a witness. You can't hold that contempt hearing. The law and statute is crystal clear. But the Judge Glanville doesn't care. He will cling to this trial until the Georgia Supreme Court drags him out of that courtroom. He stopped caring. He will deny everything, defer it forward to the appeals court or whatever's. This is unheard of.
The motion to quash. So I may, depending upon what I decide to do at that point in time, other things may be ripe. Okay.
Do you want to hear about the motion to quash, or you want to take?
No, not yet, sir. I'm going to take up the motion to quash after I finish. We finish the direct of the current witness.
Okay.
And to other issues that have been raised, as I've told some of the other lawyers here.
Next week.
There is a transcript of what occurred in the ex parte matter. I will, in fact, I'll authorize defense counsel. I'll do a privilege review and see what needs to be disclosed in terms of impeachment and or Brady. And for that, and I will do that. And then did you
hear that? This judge says that he will review the transcript and he will decide what is Brady or not Brady. He who just this lying sack of shit.
That pertained, or if that issue affects you, then certainly that may be something that at the appropriate time you'll be able to have a look at.
Well, I appreciate the court's time. We would certainly rely upon our brief and our motion, and that's a part of the record. Okay. All right. But I will reach out. The court will reach out to you on two things. One, the ability to take a look at the ex parte transcript and review it for the appropriate parts that the court will authorize. And then also for the, I'll re-notice you because I know
that transcript will have the same fate as Ms. Gautier's reports. Shredded, buried, deleted. Anything to avoid accountability for the crimes this judge committed.
I know that it's supposed to be done this Tuesday, but I doubt that we'll probably have it this coming Tuesday. If I just may say, again, Judge, I know I've already said it as it concerns the issue about you being a witness to the proceeding.
This transcript won't be done until after the 25th of that hearing. Isn't that convenient?
We don't believe that that's a bare allegation. We believe that would be an established fact at the hearing. We also,
but I can't take it. It's not something that I can argue with you at this point in time.
and I'm not trying to argue.
No, sir. You are an advocate for your client. Sure. That's the only thing I can say, but I'm not going to take up that issue right now. It's part and parcel. You made it part and parcel of the motion to recuse. So I'm saying that at this point in time, I've made my ruling. You've said what you need to say in terms of what your thoughts are. I'm going to reduce it to an order, and you can take what you want to after that. Okay.
All right. Thank you.
All right. Thank you, sir. All right. Mr. Steele, similarly, I'll reduce what I have mentioned to in an order, and you will be able to take it up as you see fit. I'm not going to grant a motion to a certificate of immediate review. Anything else?
Judge Glanville, will do anything to postpone another judge to ever take charge or even hearing about his misconduct. Now it's just postponing. Robert, yeah, that transcript will be sanitized. Here's the issue. Bumpus is a witness. If that transcript does not reflect what was said, we will hear about it. But then it will be a judge against an accused lawyer. So this is so corrupt. Mr. Steele.
I have read Baptiste versus State. I've read all the cases that I believe are applicable. I'm, best I can. But specifically, if the court would reconsider, and if nothing else, the Honorable Keith Adams and my joint affidavit in paragraph 12, we assert not a bare assertion or a legal conclusion, but we make facts that we specifically adopt from the Honorable Attorney Winchester, Collins, Banks, Nove, and Mormon's motion, where a person that they represent was in a meeting ex parte with the court and others and the prosecutor and a witness, and specifically they wrote in a pleading and under Parish, which is P-A-R-R-I-S-H versus State, which is 362 Georgia Appeal 392 Division 1, 2022. The lawyer's pleading on behalf of the client becomes a statement of the client. And they said that this court got involved with speaking with Mr. Copeland and assisted in Mr. Copeland testifying against Mr. Williams. So I've added this court to the witness list. I plan on calling the court as a witness in the trial. I added lawyers Hilton and Love from the district attorney's office to the witness list. And when I cross-examine Mr. Copeland, when that day comes, I'm going to ask him about how much pressure, if any, the court put on him. And you're going to be the one instructing the jury. And I just can't imagine how that's fair to Mr. Williams. So I just asked you, I'm not abandoning anything in the joint affidavit from the Honorable Attorney Adams and myself, but if you would just look at just even paragraph 12, again, if you didn't consume it entirely, I don't believe that meets a legal conclusion or a bare assertion. I asked the court to recuse.
I've read your affidavit, Mr. Steele, and I've consumed everything on it, and that doesn't change my ruling at this point in time, respectfully.
I also, on the transcript, I'd like the recordings and the transcript, and I object to the court going through it and deleting, because to me, the way I understand it, there is zero privilege. So I don't understand.
I'm not gonna, Mr. Steele, I can't argue with you about anything such as I've made my ruling, okay? If you have some other basis to ask for the recordings or anything like that, you're gonna have to put those in some other pleading. But at this point, Ms. Weaver is gonna prepare the record. She does that. And like I said earlier, the record should be ready soon. And you all, as a defense group, will have the opportunity to take a look at that particular ex parte transcript that was done in chambers, less anything that is totally that the court considers to be privileged. And I'm going to let you do that before you examine Mr. Copeland. So you'll have everything that you have at that point in time.
Thank you.
Interesting. It's Rebecca's story. Kayla Bumpus is friends with Miss Hilton and sorority sisters. She also was assistant DA for Fulton County through 2017. Yeah, that can create quite an interesting conflict because Miss Hilton works alongside Miss Love. But Miss Hilton, Kayla Bumpus, that's sorority sisters. Who? Thank you for the super chat. Much appreciated. Thank you so much. Yeah, this is... Yeah, the judge is lying. He's a liar. He claims he has read the cases, and then he should know that the cases supports the motions to for him to recuse himself. But he is not having it. He is not having it. He will cling to that chair until he's dragged out of this courtroom. He will do anything. And he already does it illegally to make sure that this will render a conviction and that the defendants will remain in jail. And that Miss Bumpus, in that hearing on the 25th, that she will be punished. He will not stop until the Supreme Court says, get out. I think the judge is eating breath mints or something because he has a cold. Now I have Miss Bumpus, I think. Yep, I have her motion to quash. To show cause and motion to recuse this court. So I have it here. Let's see if they are going to break.
Okay. All right. Let's turn now to the statements or interviews from January. You don't want to stick around? Okay. Well, okay. Thank you, Mr. Banks. At all. Okay. All right. Okay. Yes, you may be excused, sir.
And now the judge will pretend as if nothing happened. You absolute forkwad. Thank you. Beautiful decisions for your super sticker. Hug. It's a hug thingy. Thank you. And it's your first super on the line stream.
All right, Miss Hilton.
Thank you. Thank you so much for your Australian dollars. Thank you. I'm very honored. I'm deeply honored. Thank you so much. Thank you. Thank you. Thank you so much. Thank you to everybody for gifting memberships, super stickers, super chats. You are... That is what keeps this channel afloat. So thank you so much. Now let's listen to George Glanville pretending as nothing happened.
And counsels.
Pretending he's not a corrupt...
What matters do you have to take up from the interview?
He's a corrupt son of a bitch that shouldn't be he shouldn't be allowed into a courtroom until he is a defendant.
From the the January 28th, 2015 interview.
Your Honor, last night we sent over both the February 21st and January 28th redactions. We sent the February 21st one around 7 p.m. and then the January 28th, probably around 11:30. We have not heard from defense counsel yet, so I'm not sure if they reviewed them and if they have.
Thank you. Thank you so much. And
any additions or disagreement. So we were just waiting for defense counsel to let us know their position.
Okay. Counsels for defendants, have you identified, since now the state has sent you parts from the 28th January interview that you wish for us to talk about?
I mean, the standard is appearance of impropriety, being asshole. Or the appearance. The standard is the appearance. And he claims there is no legal basis for that, which is, July 77. Straight criminal behavior. Straight up criminal behavior from this judge. In my opinion, Fannie Willis mislove this judge, 2 or more people colluding to commit crimes. That's a criminal enterprise. That's RICO.
Mr. Sharp?
Good morning, Your Honor. I have not had a chance to digest their proposed redactions. I'm happy to talk to them about it. I've been working feverishly on getting together the redactions that we believe are warranted. Again, I'd be happy to talk to the state about that. I'd also be happy to go through them one by one with the court, however is favored. But I can't say at this moment that we've cross-referenced the 2 lists.
Okay, all right, so that's what we're supposed to do this morning, though. So does anybody else have flagged or wish to be heard on the interview for January the 28th? Sure. We're going to cover them independently. Like the January 28th, we'll cover the February 21st, and then we'll cover the June the 10th interview, and then potentially the jail calls.
I believe that myself and Attorney Steele may both have lists. I don't.
May have what? Sorry, I'm sorry.
Lists.
Okay.
But we're representing different individuals, so the list may vary a little bit. So you may be getting some suggestions from this chair, some suggestions from that chair, and then some suggestions from the state.
I understand.
Yeah. Okay. Your Honor, may we have 15 minutes to just talk to the state about their list?
Yeah. And does anybody else have any statements that they've identified from the January 28th or February 21st or June 10th, other than Mr. Steele or Mr. Sharp, that they want to bring up?
Yeah.
All right. Okay. All right. Then I'll.
And the disturbing part here is that the defense knows that this judge now have given himself carte blanche, free rein until the end of this trial to be corrupt. But they still have to play by the rule book. They have to. And they have no choice than to sit there, look at Judge Glanville and the prosecutors, knowing they are cheating, knowing they are colluding, knowing they are corrupt, and they can't do anything else about it than to object and keep filing motions. That's all they can do, because the judge has clearly, to everybody in courtroom, outside of courtroom, to you, stated he will be there until the Supreme Court drags him out.